The answer is yes and no, and it bringing along well, some undesirable results. That is, you're true in that China has made a reservation so that internal transactions are not applicable to the CTC. Now, what does that mean? A common leasing transaction, well, I do leasing, so I keep on referring to aircraft leasing. A common leasing structure nowadays involving domestic airlines and also domestic lessors is that the domestic lessors, the PRC lessor, set up SPVs, that is aircraft holding company and lessor entities in Tianjin, the city next to Beijing, because of some tax reason. Okay, so you got a Tianjin SPV leasing an aircraft to a PRC airline. It's completely domestic. Well, so far so good. It's an internal transaction, so the lease agreement cannot be registered in the IR, in the international registry. Whereas if you have an Irish lessor, for example, then the matter can be registered in the IR. So it cannot be registered. But quite often, the PRC lessors would obtain financing outside of China. Okay, they may want to borrow cheaper US dollars, for examples, from European banks, etc. Because you see, aircraft transactions are denominated in USD, right? You pay the manufacturers in USD, you receive rental payment in USD, etc. So you obtain external financing. Now, when the offshore financier comes into the picture, obviously you got a cross-border element. The mortgage, for example, that's the lessor, the borrower entity, is giving to the financier offshore, is cross-border, and that can be registered in the IR. However, the lease itself is not registerable, nor is the assignment, the security assignment of the lease, registerable. That is to say, as a typical security among the package given to the lender, the borrower, the lessor entity, would be required to assign a lease agreement with the airline to the lender as security. Now, that assignment, well, if it has been an Irish entity, could have been registered in the IR, but not in this particular transaction, because the underlying lease, which is the domestic lease which is being assigned, is domestic. Create difficulties. I also mentioned another difficulty, that is, well, we mentioned IDERA, the little piece of paper allowing the lender to repossess the aircraft. That piece of paper is supposed to be given by the airline who has registered the aircraft under its name in China. So that's why if they allow you, if they authorize you to repossess the aircraft in the default scenario, that is very good, right? But that idea is not registerable with the CAAC, that is the aviation authority in China. So, the effect of it is unclear, therefore. So, it means that the offshore lender may or may not be able to take full benefit under the K-Time Convention in a default scenario. Because of all of this, you need to do your own checking in the local aircraft mortgage register to see whether there has been any previous aircraft mortgage granted to other lenders. You have to rely on some local law authority, the power of attorney to deregister the aircraft. So you don't have the full protection under the international convention. Well, but it doesn't stop people doing transactions in China. It just makes it, you see, slightly less certain as to the result in a default scenario.